So welcome everyone to the 2021 Global Animal Disaster Management Conference. Our next session is Animals' Legal Status as a Source of Their Disaster Vulnerability, and that's going to be presented by Ashley Best. This session is proudly sponsored by the C4 Group. It's a privilege to have Ashley here with us today, and we're looking forward to her presentation. If you're interested to find out more about this presentation and about Ashley, if you go to the speakers section on the website, you can find her abstract and bio there. Before we start, I'm just going to do a few housekeeping points. So you'll see that the Zoom chat function has been disabled. So if you've got any questions, if you can put them in the Q&A section, we'll get to those at the end of the presentation. We'd like to encourage you to use the hashtag GADMConf on Twitter and social media. And there'll be a short evaluation of this session made available at the end when you leave. And just as a reminder, we are recording the sessions, but they won't be made available until we've edited those, and they'll be released as part of our GADMAC award ceremony in July. So without further ado, I'd like to welcome Ashley and for your presentation on animals' legal status as a source of their disaster vulnerability. Over to you, Ashley.
Thank you, Mel. Good morning, good afternoon, good evening, depending on where you are in the world. I would like to begin by acknowledging the Wurundjeri people of the Kulin Nation, traditional custodians of the land from which I present today in Melbourne. I pay my respects to their elders past and present, and I extend that respect to Aboriginal and Torres Strait Islander people listening today. I am a PhD candidate at Melbourne Law School, supervised by Professors Christine Parker and Lee Godden, and I research the legal status of animals in disasters. Today, I'm going to discuss how animals' legal status makes them vulnerable to the adverse effects of natural hazards. My presentation will commence with a brief discussion of how the 2019 to 2020 Australian bushfires brought the disaster vulnerability of animals sharply into the public imagination. Next, I'll provide a sketch of two major aspects of animals' legal status. These are the focus of this presentation. Then I will examine how animals' status as property under law makes them vulnerable to hazards. Subsequently, I'll outline how statutory protections for animals are insufficient to safeguard their interests. To demonstrate the inadequacy of animals' legal status, I'll rely on case study examples. Most of these come from Australia. However, I supplement these with illustrations from New Zealand and the US. Finally, I'll sketch some implications for reform. I know the 2019 to 2020 Australian bushfire season has been mentioned a few times throughout this conference. During the catastrophe, I was between Sydney and Melbourne, and even from those metropolitan centres, it was incredibly frightening. We were confronted with constant smoke, dust, alerts of nearby grass fires, and of course, a steady stream of images that depicted dead or injured animals, along with sobering news about the wider animal toll. I can't imagine what it must have been like for people who were closer to the affected regions. While preliminary studies estimated that approximately 1.25 billion animals perished in last summer's Australian bushfires, a report sponsored by the WWF updated this figure, and it concluded that nearly 3 billion native vertebrates were in the fire's path. So to give you a sense of how big that number is, if every suspected casualty represented 1 metre in length, they would lap the Earth's circumference almost 75 times. I had to do some complex maths to get to that figure. Needed some help, but I got there in the end. 75 times around the Earth if every animal represented 1 metre. Further, a separate report commissioned by the WWF to assess the impacts of the fires on koalas found that they claimed 71% of the species population in northern New South Wales. So these figures, this 3 billion animals figure, doesn't actually include agricultural animals, animals on farms. On Kangaroo Island alone, which is about half the size of Metro Melbourne, more than 50,000 sheep were reported to have died, either as a direct result of the fires or having been euthanized with injuries. So what role does law have to play? I mean, we talk about natural disasters being uncontrollable, and law is something that sort of governs social behaviour. But so then what contribution does law make? Well, my research considers how the law makes animals more susceptible than they might have otherwise been to the effects of hazards like fires. To contextualise my points, I first need to explain what sort of status animals have under law, status being sort of their legal position. So to provide you with a reference point, humans, all of us joining today, are what Western legal traditions and potentially other traditions that I'm less familiar with describe as persons. We are recognised by law as bearers of rights and obligations. By contrast, and notwithstanding that there have been efforts to recognise animals' sentience, their capacity to feel in legislation, animals are generally categorised or managed as property under law. In some cases, wild animals only become property when they're taken captive by a person. However, the point I'd like to emphasise here is that in the Western legal traditions, both common law and civil law, animals are generally classed as property or as capable of becoming property. As a consequence, they're not persons. While animals are therefore classified under law as no different to the lamp that may be illuminating your desk or the monitor through which you're watching this presentation, they do have a slightly different status to most other forms of property. Now, this is because they're beneficiaries of certain statutory protections. So my research looks at two major types of protections. First, anti-cruelty or animal welfare legislation. This protects animals against mistreatment and suffering. And I also look at environmental and biodiversity conservation legislation, which preserves habitat and regulates the killing and taking of wildlife, among other things. First, I will set out how animals' property status contributes to their vulnerability. Before I do that, I'd like to note that I conceptualise vulnerability in accordance with Blakey and others' 2003 definition, being the characteristics of a person or group and their situation that influence their capacity to anticipate, cope with, resist, and recover from the impact of a natural hazard. Similarly, the UN International Strategy for Disaster Reduction defines it as the characteristics and circumstances of a community, system, or asset that make it susceptible to the damaging effects of a hazard. So how might animals' property status amplify their susceptibility to hazards? Well, first, I argue that animals' designation as property under law makes them legally exploitable. It is this status that enables animals to be used and kept in ways that maximise their value and economic efficiency, regardless of whether the practices employed to do so exacerbate their vulnerability to hazards. So the implications of this are particularly significant for agricultural animals. The fact that these animals are property justifies contemporary husbandry practices which expose them to hazards, while also neglecting to contemplate and provide for the occurrence of disasters. So we unfortunately saw this in the Black Summer bushfires. Tens of thousands of agricultural animals perished in the disaster, either directly or, as I mentioned, as a consequence of being injured and later euthanized. In early 2020, we saw harrowing images of scorched carcasses in paddocks and along roadsides in New South Wales and Victoria. These belonged to animals who had unsuccessfully attempted to flee the impending fires. And as I mentioned, on Kangaroo Island alone, over 50,000 head of livestock, mostly sheep, lost their lives. These animals had very little capacity to actually move away from the impending fire, and this was directly associated with their status as property. It was precisely this legal construct that permitted them to be enclosed in paddocks exposed to the flames in the first place. Now, I pause here to note that these outcomes were in no way a consequence of the callousness or negligence of farmers. I don't subscribe to that view at all. My grandparents were merino farmers, and they had a deep admiration and respect for their animals. What our primary producers endured during the fires was nothing short of traumatic. Here I'm arguing that law's categorisation of animals as mere property has a direct impact on their exposure to hazards. We therefore need legal interventions or modifications to improve outcomes for farm animals in disasters. Moreover, since animals' property status makes them legally inferior to persons, so we've got persons at the top, property underneath, they are usually afforded a comparatively low priority in emergency planning and response initiatives. This was made palpable during Hurricane Katrina. So emergency transport and accommodation services were made available. However, many of these refused to accept evacuees who were accompanied by their companion animals. One particularly compelling case was that of Snowball, the small white dog who was evacuated with his young companion to the Superdome in New Orleans. When evacuees were transferred from the Superdome to a different location because they decided the Superdome was no longer safe, officers forcibly removed the dog from his young owner's arms until he was crying and vomiting. Scholars attribute this hostility towards animals in New Orleans' evacuation and sheltering policies during the storm to animals subordinate their lower status as property. So a number of jurisdictions, including in Australia, including states in Australia, have started to include animals in their disaster planning systems in response to the lessons learned from Hurricane Katrina and other catastrophes. However, their animals' interests remain widely secondary to humans. Now, this isn't terribly problematic for companion animals. It is to some extent, but it's not quite as dire for them, because the literature affirms that given the strength between humans and their companion animals, making provision for companion animals during disasters actually improves human safety. By contrast, production animals have been largely overlooked in planning instruments, both in Australia and overseas. So this trend's evident in New Zealand's National Civil Defence Emergency Management Plan 2015, which was revised following the Canterbury earthquakes to make greater provision for animals. So in writing, the plan actually contemplates the mass evacuation of production animals, rather. However, this is elsewhere in a separate document described as merely aspirational and not a current requirement. So it's clear from this that for livestock, the implications of their inferior status are quite significant. What about wild animals though? As Australia's Black Summer bushfires made plain, their status as non-persons operates to diminish their interest vis-a-vis or next to humans in emergencies. In some jurisdictions, like South Australia, wildlife rescue teams were promptly granted access to the fire grounds to locate and assess injured animals. However, in other states, there was a misalignment of views about whether and when wildlife rescuers should enter fire-affected areas, resulting in considerable delays to the rescue and treatment of animals in distress. Further, an interim report from a Senate inquiry into the bushfires here in Australia noted observations that there was only a limited ability to retrieve and care for injured and displaced animals. In these ways, the bushfires made plain that as non-persons, wildlife can make very little claim on an emergency management framework designed principally to serve the interests of law's very important people, VIPs being persons. Turning now to statutory protections for animals. So various types of, as I mentioned, various types of statutes contain safeguards, be they direct or indirect for animals. Here I focus on anti-cruelty or animal welfare legislation and environmental and biodiversity conservation legislation. It would be quite remiss of me not to acknowledge that statutory protections do confer some substantive protection on animals. So welfare legislation is particularly notable in this regard. They are an important development and they're an important construct within our legal system. However, these protections are generally quite modest and dilute. To reduce disruption to animals' enjoyment of individuals' enjoyment of proprietary rights in their animals, these protections often demand only the minimum standards necessary to keep animals alive and in an adequate state of health. Consequently, statutory welfare laws or provisions fail to address the extraordinary vulnerability to which animals may be exposed by virtue of their status as property. They're not strong enough. For example, as possessions, animals, including dogs, notably dogs, are often lawfully permitted to be tethered, at least in certain circumstances. This practice can place animals at significant risk during disasters as it prevents them from escaping impending hazards, such as floodwaters. Some jurisdictions, like Louisiana, have legislated to prohibit the tethering of cats and dogs in extreme weather conditions. However, many others are yet to follow suit. Similarly, statutory welfare protections only marginally mitigate agricultural or farm animals' vulnerability to hazards. During Victoria's Black Saturday bushfires, the code governing the welfare of cattle provided that they should be protected from climatic extremes and heat stress as far as practical, be provided with sufficient feed and water, and be kept behind adequate fire breaks. However, the sheer scale and ferocity of the Black Saturday bushfires made these requirements largely redundant. They couldn't protect animals in such circumstances, and more than 8,000 agricultural animals were killed during the fires, either as a direct result of the flames or from euthanasia. The number of farm animal casualties during the Black Summer bushfires was tenfold, notwithstanding that they too were beneficiaries of similar modest protections. The inadequacy of statutory environmental protections to safeguard the interests of wildlife during and after disasters also came into particularly sharp focus during the Black Summer bushfires. The catastrophe affirmed concerns that Australia's federal environment protection legislation, which applies only to certain listed species or ecological communities, fails to protect ecosystems and habitats in a more holistic manner. This was particularly consequential for wildlife in the fires because the availability of unburnt habitat, especially habitat refuges and connectivity across landscapes, were factors that directly influence their mortality. The catastrophe also exposed the legislation as unfit for purpose in a rapidly changing climate. Not only does Australia's federal environment protection legislation completely omit consideration of future stresses, like future disasters, but the listing processes are also long and protracted. So by the time a species is listed, they're often close to extinction anyway, or they're significantly threatened. Further, the fires revealed problems associated with rampant land clearing in Australia. And this source of habitat degradation was revealed as a human-induced factor that would have hindered species recovery. So in addition to being insufficiently robust, too weak to improve welfare and survival outcomes, the operation of statutory protections for animals are susceptible to becoming uncertain in the urgent circumstances and the unusual circumstances of a disaster. For example, the various jurisdictions affected by Hurricane Katrina, the Canterbury earthquakes, and the Black Saturday bushfires, so they are Louisiana in the US, New Zealand for the Canterbury earthquakes, and Victoria for the Black Saturday bushfires, prohibited the abandonment of animals. However, desperate circumstances left many owners with very little choice but to part with their animals. The scenes that confronted rescuers in Hurricane Katrina were likened to a war zone, as animals waited on rooftops of flooding dwellings for assistance. Likewise, one dog whose owners had evacuated without him during the 2010 Canterbury earthquake was discovered to have died from a heart attack upon their return. Comparable stories of abandonment came out of the Black Saturday bushfires as well. While instances of animal abandonment might ordinarily constitute a breach of the welfare legislation, particularly where it says, because in these jurisdictions it was a crime, it was an offence to abandon an animal, the catastrophic circumstances in which the conduct took place actually complicates the way law applies. So Steve White argues that in Australia, statutory welfare protections are likely displaced, at least to some extent, in the disaster context. The concept of cruelty is usually associated with behaviour that qualifies as unjustifiable or unnecessary or unreasonable. So where legislation says that abandonment will only be cruel if it meets one of these descriptors, if it's unreasonable, for example, dealing with a disaster will be relevant to whether or not there's an excuse. Irvine also, our keynote speaker, Leslie Irvine, also recalls how, as Hurricane Katrina approached, the SPCA warned residents that they would be charged with cruelty if they left their animals behind. Describing this as laughable, she observes that the residents who abandoned their animals numbered in the thousands. If any charges were to have been filed, it is still unclear who would stand accused. So in these ways, statutory protections are also insufficient to protect animals during disasters. So what are the implications of all this? Why am I doing this? Why am I researching this? Well, developing plans for disaster preparedness and response is crucial. We need those, and they're an excellent item or example of progress in this space. However, such plans by themselves are not, I argue, sufficient. To inform strategies to reduce animal casualties into the future, we also need to understand how their underlying legal status influences their vulnerability in the first place. Only then can we comprehensively manage their disaster risk. All right, any questions?
Thank you so much, Ashley, for a really interesting and thought-provoking presentation. So I don't have any questions on the Q&A yet. I don't know if anyone has any questions, but now's a good time to put those in and we can present those to Ashley. I find it really interesting, this idea of animals being property when it comes to prioritising or not in firefighting. Having conducted interviews with people who've been impacted by bushfires directly, concern around not being able to prioritise which property is actually defended. The house is often the thing that's defended rather than animals in this case. Is that something that's enshrined in the legal elements as well? I know that there's a primacy of human life, and human life is the focus there, and no one's really arguing with that element, but it's really talking up for the animals, speaking up for the animals.
So sorry, is your question whether or not this trend of people prioritizing house, and structures over animals, is that what you're asking? Whether or not that finds support in any legal doctrine?
Yeah. Yes.
I think yeah. The common law would say, well, they're both items of property, and I guess the thing about property ownership is that it does give you almost a form of sovereignty over and control over your items of property. So I guess that means that the law does support that kind of I guess context, or that situation in which a property owner can choose what they wish to save and what they wish to prioritize. And as we know, welfare legislation does give animals a slightly different status, but not much, and it rarely constrains the choices of owners to any great extent.
Yeah, and I think you picked up so interestingly that contradiction in terms of the law for protecting the welfare of animals, but at the same time their abandonment during disasters in massive numbers, and it's an impossible situation. And it's interesting when you start to overlay responsibility there as well, because it's certainly in Australia, the mantra is your animal, your responsibility. So there's that element of responsibility, but yet impossible choices for people still.
I think that's right. It's a very difficult policy situation policy issue to grapple with, because we're not dealing with the normal everyday. We're not dealing with ordinary circumstances. We're in a liminal state here. So I see, Mel, there are a couple of questions in the Q&A.
That's right. So Julie has a fabulous question. I love this one. Thank you. It says, what inspired you to pursue this project?
That is a very good question. So there are a few there was no one moment where I thought I have to do a PhD on this, but there are a few experiences I had. So when I was in Manila in 2014, a typhoon struck, and I was there with an animal protection organisation, and we went and visited the animals after the typhoon to check everything was fine, and it really just struck me how vulnerable they were. And then fast forward to Hurricane Florence, that probably had more of a formative impact on this project. Was during Hurricane Florence, I think there was an image of Hurricane Florence towards the end, the chicken sheds submerged in water. I just saw all the pig, the CAFOs, the pig rearing facilities. I saw these pigs just left to sort of die as they were left in their intensive farming factory farms, and some of them had managed to get onto the roofs of the various shelters in which they were living. And I just thought that it's just total abandonment that seems to be sanctioned by law, that somehow the law just has not come up with the mechanism to cope with this issue. Yet we have to some extent with humans. I mean, it's never perfect, but yeah, I felt a great sense of injustice. So I think that's probably, yeah, that was quite determinative. And then I applied later that year to start a PhD.
And many of us know that having a passion when you're doing a PhD is absolutely essential. So good response.
Indeed.
I've got a question here from Jodie. She says, what's the view on property livestock owners in reference to their legal obligations and animal welfare responsibilities when sufficient warning has been given but no action has been taken? Are they held liable, or is this on a case-by-case basis?
Yeah, look, I mean, it's tricky. For the reasons we were talking about before, that there is this strong sense that, you know, primary producers and other animal owners can make decisions for their animals. It's also very, very difficult to evacuate large herds and flocks at short notice. So I'm not aware of any prosecutions in Australia. I think Steve mentioned one in New Zealand the other day, that there was a successful prosecution where an animal owner failed to evacuate their animals. So I'll need to look into that more because I haven't come across that case. But yeah, it's so murky, and it comes back to this issue that when we are in such an extreme situation where there are competing priorities around human life, property, people aren't necessarily thinking rationally. It's very difficult. It makes it complicated to impose liability in such cases. We can talk about the concept of a duty of care, and that someone who is in charge of animals will have some kind of obligations in respect of them. But yeah, I think it's our law hasn't developed the I guess the appropriate framework for accountability in that regard. That's my view.
And that duty of care is a great segue into another question I've been sent by one of the panelists here. It says they're thinking about wildlife being considered government property. A bit of uncertainty about whether that's the case, so maybe some clarification, if you know, would be good. And the question is there any legal sense of duty of care for government property? So as an example, they're saying, considering that if the government chose to, say, burn down Parliament House, that would be viewed as government dereliction. Is there any kind of similarity or equivalence there?
Yeah, so it's really interesting, this fiction that the Crown is the owner of wild animals. So generally speaking, at common law, I think I mentioned, I can't quite remember if I went into it, but at common law, wildlife belonged to no one until the wild animal is taken captive. But in some jurisdictions, the government, the Crown, has asserted ownership of all wild animals in the territory to facilitate management of those populations. So whether or not you know, for example, the New South Wales and the Victorian and the South Australian governments could be held liable, depending on whether or not in those jurisdictions the state is the owner. Whether they could be held liable for the destruction of wildlife and the dereliction of government property. I think it's a great idea, but I don't think they'd take responsibility for it. Again, it would be the hands up in the air, but it was a disaster, a natural disaster. How could we have done anything? So I think what's important to remember there is that it's the property status of wild animals, where the Crown asserts it, it's a fiction to enable the government to more easily manage those populations and to sort of regulate hunting and the take of wild animals. It's less actually to assert responsibility, if that makes sense.
Yeah. And I've got Steve Glassy just saying here that in New Zealand, the wildlife are owned by the Crown, but the Animal Welfare Act excludes them from liability. So that's sorted.
Yeah.
And one probably final question, I think, I'm not sure, I'll take a look at the other questions, is does the law in Australia need to be revised at the state and federal level, do you think? And what would an ideal legal framework to protect animals look like in Australia? Obviously, we can't talk about everywhere.
Oh, wow. I feel like a kid in a lolly shop with that question. I'm like, oh my goodness. So first of all, I think we need cohesion among the states. So Mel, I understand you're doing some great work with the planning principles to try and get that consistency. So that's one thing, because, you know, floods, disasters don't respect state boundaries. The other thing that we need a very comprehensive preparedness and response framework for when animals are for when a disaster is impending, that doesn't sort of relegate animals on the basis that they are mere property and less than humans. We need to sort of recognize our responsibilities to them independently of you know, their status, their legal status, until that is modified. And then on the other hand, we also need to start thinking about how we reduce their vulnerability in the first place. So a great example with wildlife is stop, you know, clearing their homes and give them places where they can, you know, opportunities to flee from disasters, maintain those wildlife corridors. With livestock, it might be thinking about where we can, the kinds of paddocks and the sorts of infrastructure that we need for them that would reduce that vulnerability to hazards. So it's that sort of comprehensive, holistic Australian approach, which would be, it's going to be very difficult in Australia's federal context, but also thinking about the immediate disaster, but also thinking more broadly about those drivers of vulnerability.
Definitely. I do have one final question here. Liz asks, what legislation could responsibility for taking care of animals in disasters sit under? And she divides that into the companion animals and the livestock.
Yeah, so I guess there's two options really. The first is welfare legislation. It's perfectly reasonable to think that anti-cruelty legislation could deal with both. Livestock are generally regulated by a scheme of codes of practice, which are moving to standards and guidelines now in Australia. So it's quite separate to deal with that distinct situation. But so welfare legislation and codes of practice could manage it, or alternatively, we could include them in our emergency planning frameworks more holistically. So we've got plans in 4 states specifically for animals, or sort of frameworks for assisting animals in disasters, but we could ensure that they're integrated in every state in a sort of more comprehensive way. So yeah, welfare legislation or emergency management would be my guess.
Brilliant. Okay, well, thank you, Ashley. I think we're coming towards the end now. And I think it's been really interesting for us in the conference to consider how the law impacts vulnerability. And yesterday we had a great presentation about the media and the role they play in portraying animals in Portugal in this particular instance, and how that actually impacts on the vulnerability and the way in which animals are viewed and looked after. So I really thank you, as one of our attendees does as well, for something that's very thought-provoking, and it is indeed thought-provoking. So thank you, Ashley, for your time today. Thank you also to all the attendees for being here at GADMAC. Our next presentation is just under an hour and a half away, and it's going to be on wildlife conservation, principal approach to prevent biological disasters. So we'll see you again in about an hour and a half. Thank you.
Thanks so much.